Greetings and welcome to Blackhat USA 2010. This is the special events track, and you're here for the continuation and finale of Hacker Court. It's a small session, so please feel free to come to the center. And to give a recap of the first half and start the second, I present to you Richard Salgado, who's playing the judge.
So where we left this before the break was we had heard some opening arguments about a case in which a business that was run by Biz Zuckerson had an intruder come into the laptop of Biz and enable the webcam and do some other nefarious stuff on the machine. After an investigation that was led by their chief security officer, they got somewhere but not very far, so they called in the police who furthered the investigation, ultimately leading to the seizure of a computer by the defendant where they found some of the proceeds of the hack of Biz's laptop. We heard that there were 3 charges that were brought against the defendant. One, for enabling the webcam and thereby capturing communications that would be illegal under the Wiretap Act, so the prosecution's theory would hold. Second, that the evidence showed that the defendant, according to the prosecution, had also intercepted instant messenger communications, also under the government's theory, a Wiretap Act violation. And third, that in the course of the intrusion on the laptop, the defendant was able to obtain some information, a violation of the Computer Fraud and Abuse Act, the federal hacking statute in the United States. And you've heard from a series of witnesses. At the close of the prosecution's case, so we've heard from all the prosecution's witnesses, we had a motion from the defense counsel, which is standard in criminal trials, to acquit the defendant, meaning to find the defendant not guilty, on the theory that the government had failed to prove beyond a reasonable doubt in its own case the essential elements of any of the crimes. And the defense can make this motion even without having presented its own case, if it's going to present a case, because it's up to the prosecution to have to be able to show the elements of the crime beyond a reasonable doubt. So that was the motion we heard right before we took a break. The focus of that motion was really on 2 points. One, that the charge against the defendant for illegally intercepting oral communications fails because there was no interception of the human voice. It was only video that was captured, and the statute requires some oral communication being acquired. The defense counsel provided a litany of cases that suggest this is accurate. The prosecution valiantly tried to save what this court would find as being an obviously bad charge to bring against the defendant in this case by arguing essentially policy grounds, that we ought to have a statute that says that video surveillance of this nature is illegal. But as Mr. Bankston points out, and I'm now reprising my role as the judge.
Just play the video just so the jury can have a chance to see it.
To show the video of the, oh sure, so this is the video of that was captured. And you can't hear any sound.
Is that their badges from last year at Blackhat? Because certainly this isn't from yesterday or minutes ago.
These are badges issued at the party, apparently. And is that Bieber in the back?
That's Bieber in the back, yeah.
The bald guy?
There's Karl Rove, I believe.
Okay.
That was our video.
So that's the video that was allegedly intercepted in violation of the oral interception provision of the Wiretap Act. So as the judicial official here, my job would be to rule on whether the prosecution after its case has failed to present a case that was worthy of finding the defendant guilty. And in this case, I will so find that although the statute provides for that there are some types of information that you cannot intercept, it does not include pure video. And as bad a policy matter as that may be, as the prosecution has indicated, that's a matter for Congress to take up and not an issue that the court will suddenly and out of whole cloth impose criminal liability onto a defendant. So my ruling number 1 is we will dismiss count number 1. You would not, as jurors, actually hear this. As jurors, you're going to magically find that this suddenly became a case only 2 counts and no longer 3 counts. You wouldn't be advised of all the ins and outs of this. But given our lack of formality here, you're in on that. The second argument the defense counsel raised was that the prosecution didn't show financial motive or commercial advantage behind the alleged conduct that would make the hack into the machine a felony. So the argument is, in order to show a felony hacking to obtain information, the motive of the defendant had to be to make some kind of profit. I am, as the judge, going to deny the defense motion to dismiss on that ground and leave it up to the jury to decide whether there's enough evidence to show the motive of the defendant was to make some kind of profit. And I will be instructing the jury on some of the grounds to decide that issue. So at this point, I'm granting the motion to dismiss count 1, I'm denying the motion to dismiss count 3, and I'm denying the overall motion to dismiss all counts on failure of the prosecution to sufficiently prove its case. Having ruled on that, we will now move on to the next section of the trial. We'll bring the jurors back in, you're here, and now I'll turn to the defense counsel. Defense, do you have any case you would like to bring?
Yes, Your Honor. We'd like to call Joel Hobbs to the stand.
Mr. Hobbs, will you raise your left hand, please? Do you promise to tell the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Hobbs, could you state your name and title for the record?
My name is Joel Hobbs. I'm a principal security analyst.
And give a little bit about your background.
I am qualified for doing security reviews of applications, systems, and forensics work.
I'd like to remind the judge that Mr. Hobbs has been previously qualified as an expert in computer and network forensics and computer security.
I remember the hearing well. You are qualified to testify as an expert.
Okay, Mr. Hobbs, have you reviewed any of the evidence in this relating to this case?
Yes, I've analyzed image copies of the hard drives from 3 computers, Mr. Zuckerson's laptop, the computer belonging to an employee named Mr. Brutish, and the computer seized from the defendant. I've also analyzed the architecture of the MyTwitFace network.
And did the prosecution give you copies of the original evidence?
No, I was given image copies of the 3 hard drives.
And what were you looking for?
I was trying to reconstruct exactly how Mr. Zuckerson's laptop was compromised, and I was trying to trace how 3 pieces of evidence were generated: the silent video of the party, the screenshot of the IM conversation, and the PowerPoint file.
All right, let's start with the compromise of the laptop. Did you determine how the laptop was compromised?
Yes. As it happens, my firm discovered a flaw in the software used by the Lower Merion School District. I looked first through the compromised computers to see if a similar flaw was used to access Mr. Zuckerson's laptop.
What did you learn?
In the Lower Merion case, the school district used a software package called LandRev by a company called Absolute Software. The problem with LandRev turned out to be the way it authenticated with the server.
And what was wrong with the authentication?
Well, when a computer running LandRev tried to phone home, it first verified itself to the authorized server by encrypting a message with a shared key.
Well, what was wrong with the key?
Well, the LandRev software had the key hard-coded into the binary, and it was thus very easy to recover with a simple hex editor.
And what was the key?
Well, in the Lower Merion case, it turned out to be lines from a German poem.
Turning to this case, did the Absolute managed software used by Laptets on MyTwitFace suffer from the same problem?
Yes, I found the key hard-coded in the software.
Was this how Mr. Zuckerson's laptop was compromised?
It appears so. I learned a lot when I looked at Mr. Brutish's desktop computer.
What did you learn?
On Mr. Brutish's computer, I found a piece of software that started up with the system. I call it Solitary, Poor, and Nasty, or SPN.
What does SPN do?
I did an extensive analysis of SPN. SPN performs what computer security experts call a man-in-the-middle attack.
Could you explain a man-in-the-middle attack? What is this?
SPN pretends to be a control server for ambiguous manage. When a computer running the ambiguous managed surveillance system first tries to register with the AM server on the network, the computer running SPN, in this case Mr. Brutish's, mimics the responses that would be sent by the AM server.
Using the hard-coded key.
Yeah, that's an important part of it. SPN mimics everything the server does, down to the key, and it does so very quickly. So quickly that the client computer is fooled into trusting it.
And what can SPN do once it becomes the server?
Anything ambiguous manage can do.
Could you give some examples?
It can take screenshots. It can turn on the laptop's camera. It can download files from the laptop.
Okay, so the functionality that was built in to that enabled this evidence to be created was already built into the software that was installed by MyTwitFace.
That's right.
Let's talk about the screenshot. What happens when someone uses SPN to tell a client to take a screenshot?
Well, the computer running the client copies all of the bits in the computer's video memory into a file on the client computer.
And is this screenshot transmitted across a network?
Well, not immediately.
Well, so how do the screenshots get pulled off the computer?
Well, the AM API includes a call for sending a file to another computer using the file transfer protocol.
All right, so just to clarify, because this is important, you're saying that the screen grab exploit didn't capture any instant messaging data as it was sent between the CPU and the network interface?
No, it grabs the content directly from the video buffer that feeds the monitor.
No further questions.
So it's Mr. Hobbs. Did you take this SPN code that was running on Mr. Brutish's computer and compare it to anything on Weasel's computer? You said you had images of that too.
Yes.
And what did you discover?
Well, Weasel's computer had a binary that matched the binary on Brutish's computer.
Is my mic on? Hello? Yeah, I think it's on. Was this an exact match?
Yes.
Okay, so let's talk about this ambiguous managed product again. Can you tell, based on the way you've deciphered and untangled the way this all happened, whether the CEO's laptop was connected to a network at the time the screenshot was taken?
Well, it had to been to get the command from the Mimic server.
And so, I'm sorry if I'm being slow, what would have happened if the laptop wasn't connected to any network at that moment in time?
Well, the server wouldn't have been able to transmit the message to make the screenshot.
All right, so let's talk a little bit more about this network. You said, I think, you analyzed the network diagram of the MyTwitFace network. Is that correct?
Yeah, they all have wireless and wired network cards and TCP IP stacks.
And so they're all, again, just to be slow, they're connected to the internet, these computers?
Yes.
Okay. And so can you tell if at the moment these computers were compromised, they were in fact connected to the internet at the time the screenshot was made?
Well, as I said, Mr. Bruce's computer and Mr. Zuckerson's computer had to have been communicating in order for the screenshot to have been made. And every computer on the network could access the internet.
Okay, thank you. No further questions, John.
Any redirect, Mr. Opsahl? Okay. You're dismissed. Thank you. Any additional witnesses?
Yes, sir. We would like to call to the stand the defendant, Mr. Weasel.
Dun dun. They do it every year.
Mr. Weasel, would you raise your left hand? Do you agree to et cetera, et cetera?
Et cetera, et cetera.
Please state your name for the record.
Weasel.
And what is your title?
Titles are for narcissists. I'm senior software engineer for Vapor Espora? Vapor Espora, thank you.
Yes. Do you have a prior relationship with MyTwitFace?
Yes, I worked there previously.
And what did you do there?
Senior software engineer.
When did you leave MyTwitFace?
About 2 years ago.
And why did you leave?
I had a difference of opinion with management over the use of the customer data and violations of privacy, in my opinion.
And where do you work now?
I work for myself doing contributing to the open source project.
Okay. So are you an employee of?
I am not.
Do you receive a salary?
No, I do not.
And what is this Vapor Espora project?
It's an open source peer-to-peer social network system that's focused purely on privacy of the user's data. It does end-to-end encryption, and it has decentralized administration.
And would you say that Vapor Espora is your project?
No, it's not. It's open source. It's everyone's project.
So do you have any ownership interest in it?
No, I do not.
Okay. So what do you do for money?
I do okay. I get by. I live simply. I've got plenty of money left over from when I worked with MyTwitFace.
Are you responsible for the screenshots and videos of Biz Zuckerson that we've been talking about today?
Yes.
And how did you acquire these materials?
It was fairly easily. I knew one of the employers or employees of MyTwitFace, which is British, and I knew he used a very simple password scheme based on his pet's name, Snuffleupagus.
Snuffleupagus? What kind of pet is that?
I don't know. I've never seen it.
So you just used that name, typed it in?
Yeah, just did minor substitutions for letters, for numbers, and things like that,
Okay, and then so
or vice versa.
you got inside, and well, we just had the description of how it occurred from the expert. Why did you do this?
Because there are millions of users that were having their data used against their will, and I felt that everybody needed to know about the exploits of this douche nozzle sitting over here.
And you were familiar with him from your days at my.
Oh, yes, I was. He was the
Yeah,
oldest.
objection, Your Honor. That's just not nice. Could you
He's,
please advise the witness to be nicer?
I overrule that. Encourage hostility.
Okay. Well, so why not just go public with what you knew as a former employee, and not do the video and the screenshots?
I felt I needed hard proof so that it wouldn't be just another blank accusation or
So-
unfounded accusation.
And then after this controversy arose, a lot of controversy, was there not?
Yes.
And then users increased at VaporAspera after this became public?
Yeah, subscription increased by 75% the first month, and my friends list doubled.
Oh, okay. But do you make any more money?
No, I did not.
So the more users there are, that doesn't affect
No.
how much money you make.
No,
The more friends that you have doesn't affect the more money you make.
no.
Did anyone pay you to conduct this exploit?
No, they did not.
Are you aware of any plans to monetize VaporAspera?
No, we have no plans to monetize Aspera. We've promised to our users that we would never use advertising, we would never share their information.
So
Its sole purpose is to promote free speech and sharing of Farmville assets.
and anyone is free to download the code and make a competitor with you using the same code? And
Absolutely.
did you expect to receive anything at all, anything of value out of this hack?
Out of the attack? No, I just wanted to expose this asshole's evil plan.
Yeah, that one's okay. That's accurate. It was the early one.
Well, I understand you have strong feelings about the CEO and that this was, but were you doing this to hurt my TwitFace?
Not so much. I just wanted people to know the truth. Then they can basically make their own decision.
No further questions.
So it's Mr. Weasel, is that correct?
Yes.
Okay, Mr. Weasel.
Mr. Weasel, period. My last name is period.
Okay. Mr. Weasel, period. My last name is period. One of the pleasures of preparing for this case is I got to watch the video of you speaking at the Fred conference. That was really an impressive show you put on.
Thank you.
Seemed like a really good conference. Did you have a good time there?
Yeah, it was a great conference. It's much better than TED. It's +1. TED +1.
And as we heard in earlier testimony, it sounds like they gave you a pretty substantial sum of money to speak at Fred.
They gave me money to cover my expenses, yes.
It sounded from earlier like we were talking about more than just reimbursing expenses, weren't we? This was an honorarium. This was a $5,000 check.
My expenses are high.
And do you think you would have received that invitation were it not for this big privacy controversy?
Objection. That calls for speculation.
If you rephrase the question into a motive question, we might allow it.
Okay. So let's talk about your history with Fred. Had you been invited to Fred before?
No.
And so this unprecedented invitation came immediately after the news broke, correct?
There was a day.
And when the invitation came, the person who invited you specifically asked you to talk about this big privacy controversy. Isn't that correct?
Yes.
And aren't you now better known than you ever were before any of this ever happened?
Yes. Well, yeah, I get more emails.
Do you get more emails, invitations, things like this?
Sure.
And then you also testified further that in the first month after this happened, your user base increased 75%. Is that correct?
Yes, in the first month.
So criminal actions that you took led directly to more money for your project. Isn't that fair to say?
Mischaracterizing the testimony.
All right, let me rephrase this. That's okay, Your Honor. You disclosed the video. You published this information to this journalist. This led to a lot more users on Vaporaspora for a project for which you are the lead coder. Is this correct?
No, not so much so. I don't agree with that. I think that the users came because of the effect on the being exposed to the effects of their privacy, not because of anything else that I did.
All right, we'll let the jury decide that. Thank you, Your Honor.
Any redirect? The witness is excused. Defense, do you have any other witnesses?
No, Your Honor.
All right. Are there any other issues that we need to raise outside the presence of the jury?
Yes, Your Honor, there is.
Proceed.
Defendant, again, like to bring a Rule 29 motion, renewing our motion for acquittal. And in particular, we would like to move for acquittal on count 2 regarding interception of electronic communications. Based on the definition of electronic communications in the wiretap statute, the wiretap statute only protects communications, electronic communications, such as instant messages, that are, quote, transmitted in whole or in part by a wire, radio, electromagnetic, photoelectronic, or photo-optical system that affects interstate or foreign commerce, end quote, such as the internet. However, much like a key logging device, which does not capture communications being transmitted over the internet, but only the keystrokes being transmitted between a keyboard and a computer CPU, the exploit here did not intercept Mr. Zuckerson's instant messages with his friend, which were transmitted over the internet, but only acquired those communications that were purely internal to Mr. Zuckerson's computer, between his screen buffer and his monitor. Hence this jurisdictional prerequisite that the communication at issue be transmitted over a system affecting interstate or foreign commerce was not met, and no electronic communication, quote unquote, was ever acquired. Only communications between components of Mr. Zuckerson's computer. I think this conclusion is mandated by the reasoning of US v. Ropp, a 2004 case concerning key logging, that we believe was correctly decided by the Central District of California. There, Mr. Ropp was indicted for attempting to intercept the communications of a coworker in violation of Title III of the wiretap statute by installing a device called a key catcher on the cable that connected her keyboard to her computer CPU. And that device recorded the keystrokes transmitted between the keyboard and the computer. The court in Ropp concluded that even though the victim's computer was connected to the company's network, which qualified as a system affecting interstate commerce, and even though the keylogger captured keystrokes used to compose emails and other communications to be sent over that network, there simply was no interception in that case, because the only communications captured were the internal communications between components of the computer that occurred prior to the transmission over the internet. Therefore, as the Ropp court concluded, and I quote, the communication in question is not an electronic communication within the meaning of the statute because it is not transmitted by a system that affects interstate or foreign commerce. The system involved consists of the local computer's hardware, the CPU, hard drive, and peripherals, including the keyboard, and one or more software programs, including the computer's operating system, and either an email or other communications program being used to compose messages. Although this system is connected to a larger system, the network, which affects interstate or foreign commerce, the transmission in issue did not involve that system. The network connection is irrelevant to the transmissions of keystrokes between the keyboard and the CPU, which could have been made on a standalone computer that had no link at all to the internet or any other external network. We think this logic is compelling, and this logic applies the same in this case. The screen capturing exploit at issue here, like the key catcher in the Ropp case, did not monitor communications going through the computer's internet ports and out to the broader internet, or from the broader internet, which is unquestionably a communication system affecting interstate commerce. At most, and independent of any transmissions made over the internet, The exploit captured only the transmission between the computer's video buffer and its monitor, transmissions that were completely internal to Mr. Zuckerson's computer. Therefore, those transmissions were not electronic communications under the statute, and any acquisition of those transmissions was not an interception in violation of the statute.
Do you have any additional argument?
I do not.
All right, thank you. Mr. Ohm, do you have an argument against
I
the
do, Your
motion?
Honor, and unlike last time, to use the technical term when I had my ass handed to me, the defendant has one case that it cites, and it's a case out of the Central District of California. And with all due respect to the court in the Central District of California, you know, I don't need to tell you that this is not binding on this court. This is just precedential. But that said, I'm happy and willing to explain why we, the government, believe that ROP was wrongly decided. And even if there is some internal logic to ROP, and we're not going to concede that, we also think that this case is distinguishable. So once again, what the defendant is doing and what the court in ROP did is it's elevating this strange formalism. So here we have Title III of the Wiretap Act, and it's supposed to be about the acquisition of the contents of certain kinds of communications. Now, of course, we are a federal system. This does have to, as the slide here indicates, involve a system that affects interstate or foreign commerce. But if you parse the language very closely, you'll see two very interesting words that I think we need to meditate on a bit more. One is the word affects, and one is the word system. Let's start with the word system. The defendant, if I'm following correctly, would have you believe that the only system that is protected is the network interface, the wire, and whatever network interface is on the other end. That the word system that Congress used but did not define can't be defined to include anything that happens on the other side of that network interface. That if the only thing we're talking about is the CPU, the video buffer, the bus, for some reason Congress decided that this comprehensive, expansive privacy law won't extend those 18 more inches into the computer. And we think this is just a facile argument, and we're very surprised that the court in California, in the Central District, embraced this. We think the better argument is that the word system means the entire system, the network. And I think, again, doing as I did a second ago, references to an ordinary English dictionary about what the word system means would bear that out. That the word system is broad enough to show that Congress meant not just two cups and the string in between, but it can also be the computer on the other end. That's our first argument. Our second argument is that the word affects, even if you're willing to take a narrow view of the word system, the word affects gives the court the opportunity to understand that Congress meant something that is broader than just a narrow definition of system. And for this, I will actually point you to other district court authority we think is much better reasoned. This is Potter v. Havlicek out of the Southern District of Ohio. This is a court that was decided after ROP, cited ROP, and disagreed with it. And in this court, they said the ROP court misunderstood and misread the definition because they neglected the word affects. And even if we were to define the system to exclude the little bit, the 3 inches between wherever the video buffer RAM is held and the CPU, even if we're able to do that, this still affects the larger system. In this case, we're talking about instant messaging. The thing that was intercepted were the communications between people on an inherently worldwide internet-based network. And so it just doesn't make sense to read in this constrained way. The final thing I'll say about this is the Potter case also involved screen capture, like we're talking about here, unlike the ROP case, which was just keyloggers. And so there's a different dynamic about the types of messages that are stored and the types of messages that are intercepted. So for all these reasons, we urge the court to deny this motion.
Thank you, Mr. Ohm. Appreciate the briefing on this and the concise argument here. It's clear to me, and it seems conceded by both parties, that the communications that were acquired here were internal, that there was not a sniffing of the wire to pick up communications as they left a device or were transiting to another device. And as a lifelong judicial official, I'm very familiar with the internal workings of computers. But I do think that the question here is really one of a fact for the jury to decide. First, whether this actually affects interstate commerce, And second of all, whether the system is broad enough, the term system is broad enough to include that portions of the laptop that were affected here, such that the Wiretap Act in this case would actually cover the acquisition of the data as it sat in video RAM. I'm going to leave that question for the jury to decide. I think the other courts have determined that that was actually a question of law for the judge to decide. I may revisit that. But at this point, I'm going to allow that to go to the jury for the jury to decide. So I will not be dismissing count 2 of the indictment. Are there any other matters, prosecution, defense, that we need to raise at this point?
No, Your Honor.
Thank you. All right. That leads us to the final phase, or the last couple phases of the trial. You've heard from all of the witnesses that both sides have to present. And I will remind you that in order to convict the defendant here, you've got to find that the prosecution has proved beyond a reasonable doubt each of the elements for each of the charges. If you do not conclude for any particular charge that an element has been satisfied by the government, then you must find the defendant not guilty on that count. Reasonable doubt is proof that leaves you firmly convinced that the defendant isn't guilty. There are a few things in this world that we know for sure and that we have absolute certainty about, and the criminal law doesn't require that level of conviction. It really requires that the government's proof exclude any reasonable doubts about the conclusions which it's drawing about the defendant's guilt. That said, the presumption here is that the defendant is not guilty unless you are convinced that there's no reasonable explanation for the evidence that has been presented that shows the culpability of the defendant. There's a couple charges here that we're going to talk about. The first one is the remaining wiretap charge. On this account, the prosecution has to prove, again, beyond a reasonable doubt, that the defendant intercepted electronic communications, and in this case we're talking about those instant messages. There are really essentially 3 elements that have to be proved here. First, that the defendant intercepted something. Second, that that something was an electronic communication, which is a defined term. An electronic communication, as you can see from the slide, is any communication where there's a transfer of signs, signals, writings, images, sounds, data, or intelligence of any nature that's transmitted by a wire, radio, electromagnetic, photoelectronic, or photo-optical system. And as you heard before, it also has to affect, the system has to affect foreign or interstate commerce. It's also important for the government to show that the interception was intentional. So it's up to you to determine if the government has satisfied each one of these 3 elements with their subparts beyond a reasonable doubt. On the third charge of hacking, the prosecution alleges that the defendant intruded upon this computer and obtained information. To prove this charge, and for you to find the defendant guilty here, you must find that the prosecution has shown beyond a reasonable doubt that the defendant intentionally accessed a computer and did not have authorization or exceeded whatever authorization the defendant had, and in doing so obtained information from a protected computer. And I will note that in this case the sides have stipulated that the computer here falls within the definition of a protected computer, and that the defendant committed this offense for the purpose of commercial advantage or private financial gain. Again, if the prosecution fails on any one of these 3 elements, you must find the defendant not guilty on the overall charge. At this point, now that you've been duly charged with instructions on how to reach a verdict, we turn to the closing argument phase, and the prosecution goes first. The defense, if it wishes to offer a closing, would go second, and the prosecution, if it elects, would have a rebuttal. Mr. Ohm?
Thank you, Your Honor. Ladies and gentlemen of the jury, I really do thank you for your patience. The government likes to say that we never present a closing argument, we present a summation, because we think that the facts of this case, as with every case that we try and bring, establish beyond a reasonable doubt that we have met the burden of what we are set out to do, which is to show you that the defendant here has committed a wrongful act. Now, the judge has talked to you about the intricacies of these I'll admit it, kind of strange laws that use lots of words that have highly technical legal definitions. The really good thing, I think, for the jurors to understand is that we're talking about 2 counts here, and each count has 3 different things that we must prove. And although I'll go through and show you in this closing argument, the summation, how we've met each of those 3 things, in reality, there's really only one thing being disputed for count 2, and there's only one thing being disputed for count 3. And I think that's where we'll spend our time. Count 2 is about the screenshot that was taken of the instant messaging conversation. And the question here is this an unlawful wiretap? I think it's hard to dispute that there was an interception here and that this interception was intentional. You heard the testimony of Agent Stroker, who found copies of the screenshot that were made by someone who exploited absolute manage software. You heard that this software was exploited on Brutish's computer. You found that the identical software was found on the defendant's computer. You've learned that the journalist received a copy of the screenshot, and you learned that the defendant had a copy of the exact same screenshot and the exact same email message on his computer. Then you heard from the defense expert, Mr. Hobbs. And in step-by-step detail, he provided proof. He provided the trail that the defendant, Mr. Weasel, took as he made these unlawful copies. Second is the requirement that this was an intentional act. And we don't always have such an easy job of this element in federal court, but the defendant admitted it. The defendant, under questioning from his own attorney, said, I did it. I did this act. And so as I promised you, this first count number 2, really turns on this definition of electronic communication. And what you need to determine as a jury is, did the screen capture, which the government concedes happened on one computer, involve a transfer of information in whole or in part by a system that affects interstate or foreign commerce? And I think we've plainly established that these computers that were connected to the internet satisfy this. Please turn with me to count 3. Count 3 is under the federal hacking statute, the Computer Fraud and Abuse Act. And again, I think we have the same story here. 3 elements, but only one is really in dispute. Element 1, intentionally accessing a computer. This is satisfied completely, fully, and beyond a shadow of a doubt through the confession of the defendant. Step 2, information was obtained. You've seen the PowerPoint slides that resided on Mr. Zuckerson's computer that were lifted through Mr. Brutish's computer, and a copy of which ended up with the defendant and ultimately with the journalist. Element 2, I think, abounds with evidence in this case. So this, again, brings us to the third and final element that you must look at in this case. And you're going to hear, I predict, from the defense, a very long, convoluted argument about how the government failed to prove that what this case involves is either commercial advantage or private financial gain. But what I want you to do is, when you get back to the jury room, to study the evidence, what I think is the ample evidence of both of these things. Number 1, commercial advantage. The judge did not define what this means for you. And that's because the law doesn't either. You're supposed to be guided by your understanding of the ordinary English language about what these words mean. Commerce. This doesn't say anything about the corporate form. It doesn't say anything about employers and employees. It only says that your motive, at least as far as you can divine, was commercial. And I think that when you look at the evidence, when you see that defendant was the lead coder, the inspiring force, the person who was associated with the Vapor Aspera project, the Vapor Aspera project, by the way, which was a direct competitor of MyTwitFace, you'll see the motive of commercial advantage. The defendant is going to make a big deal about the fact that our case is circumstantial, and I concede that. We don't have a smoking gun email that says, this is my motive, I can't wait to do it. That would be wonderful. It would have saved us a lot of time in court. Instead, what you need to do to jurors is dig into your well of human understanding. Look at what happened immediately after the compromise. Look at the email messages that we've presented before you and ask yourself whether this sounds like commercial advantage. The user base for Vapor Aspera climbed 75% in 1 month. People were abandoning MyTwitFace and going to Vapor Aspera. The defendant on the stand said, there are no immediate plans to monetize this project, but there could be in the future. So take that back with you, jury room, and ask you if that satisfies commercial advantage. And then I think you should also look at the evidence of private financial gain. A mere 24 hours after this occurred, the defendant was offered $5,000 in an honorarium to give a speech. Since then, other similar opportunities have come in. His email accounts have begun to grow in leaps and bounds. The number of friends he has on his social network have begun to grow as well. There's a great amount of private financial gain that was obtained. It's for you to decide whether this was the motive animating the attack. One other thing I'll say about motive. You can find in your heart that the defendant had more than one motive. Now, the defendant sure thought that this company was a bad company and needed to be taken down, but also that there was a commercial advantage or private financial gain. And that brings me to my last point. My twit face isn't on trial. Sure, you've seen some testimony of some people that you may not think are the nicest people in the world. You might be glad that you don't work under the heavy hand of Maria Batali as your computer security person. You may not think that the CEO is someone you'd want to bring with you on your next family vacation. They are not on trial. This is not about the company, but the defense counsel, through their questioning, and I predict in their closing argument, will try to make this about the company. The only person who is on trial is Weasel. And look at his actions. Ask yourself, is this the kind of person who's a hero, who's a paragon of virtue, who's someone we should celebrate, or is this a person who broke the law and who should go to prison? Thank you.
Mr. Upsall?
Thank you, Your Honor. And ladies and gentlemen of the jury, Mr. Weasel is a hero. And we've seen the efforts that he has made to bring the truth about my twit face to the public. And he's right that about a few things. They're rare that we will agree with the prosecution, but it does come down to primarily two things in counts 2 and 3. But as the jury, you need to find everything in each of these counts. So the government has to prove all three beyond a reasonable doubt. And if any single aspect of these counts is not proven beyond a reasonable doubt, you must acquit. And you have to consider all the evidence presented by the prosecution and determine the facts, whether they have shown as a factual matter that the communication that was intercepted at the point of the interception was in a part of a system that affects interstate commerce. And you have to find, for the hacking count, that Mr. Weasel's motive was private financial gain or commercial advantage. And they have not shown that. For the wiretap charge, the screenshot captured a local activity, an activity on the computer, and that's not part of a system that was affecting interstate commerce. There was no evidence, for the hacking charge, there was no evidence that Mr. Weasel had a purpose of commercial advantage or private financial gain because, well, let's start with the wiretapping charge. It's designed for the interception of phone calls. In the modern age, it's also been applied to electronic communications like emails. But what we have here is a screen grab. A screen grab goes beyond the scope of the statute. It is not something that is part of the electronic communication. Now, it may be that prior to the screen grab, Mr. Zuckerman was engaged in electronic communication with somebody else, going back and forth on the instant messaging. But that communication at the point of capture was between the video buffer and the monitor. It was put over to the file system. It was something entirely internal to the computer. So you have to think about what is the system at issue. I like to think that the system is large, that it is the system that would include everything all the way through to the internet. But the system that was captured was the system inside the computer. You don't have to say it stops at the network interface card and that not 18 inches inside the computer, because here it didn't go. It was not captured between the CPU and the network interface card. It was captured elsewhere and locally within the system. And as Mr. Hobbs testified, the program simply copies the bits in the computer's video memory into a file on the client's computer. Nor is it important what happened after it was captured. After it was captured, it may have been transmitted over the internet, over a system that affects interstate commerce. But that's not important to the charge because it's beyond the point of capture. The only thing, the only fact that this jury needs to look at is what was going on at the point of capture. And if you don't have the necessary elements to show that the system upon which it did the exploit, made the capture, was a system in interstate commerce, you must acquit. Now, with respect to the hacking case, we're not contesting that Mr. Weasel got onto their network. He admitted as much. He's being honest with you. He's upfront about what he did. And the reason he's upfront of it is because he believes in what he did. Maybe that's wrong. Maybe he shouldn't have done this method to expose people to public. But he was willing to do it. Think of that as perhaps some civil disobedience, that he was taking a hit in order to bring some information to the public. And perhaps if it had been charged as such, this might have been a misdemeanor. But what it is not is the felony that they have charged. And the key to that is what the motive, whether or not this was done for commercial advantage or private financial gain. The evidence shows that Mr. Weasel acted simply out of a motive to help the public. And the public was helped. He wanted to let the public know who was behind my twit face, and then the public could make its own decisions about where they should go and what they should do with their social network. Now, many of them did choose to come over to Vapor Aspera and leave my twit face. But they did so based on the truth of what was shown to the public, based on the information that was done. That is the natural consequence of it. But that is not a commercial advantage to Mr. Weasel. He is not an owner of Vapor Aspera. There is no owner of Vapor Aspera. It is something which anyone is free to use, and he gets no money anytime someone uses it. He doesn't receive a salary. He doesn't get paid as a consultant. He has no shares to sell. There is no advantage to him personally for more users to come to Vapor Aspera. Now, the evidence also shows that he was extremely passionate about privacy. And I think it seems that that was a genuine belief. Now, Mr. Ohm would say, well, okay, he seemed to concede that, but say, well, there might be two motives. But the evidence wasn't there to show two motives. The evidence instead showed a single motive, and a single motive to help people's privacy. Now, Mr. Ohm, the government, would like to make a big deal about the invitation to the FRED conference. This invitation occurred after the exploit took place. It was not something that he had invited. It was an email that came to him out of the blue. He had no reason to expect that would come. He had never been invited to the FRED conference before. It was not something that was in his mind. And one thing that is critical when you're considering what his motive was is the motive at the time he did the exploit. His motive when he went on the system. When he went on the system, he didn't even know what was going to be there. I mean, he had some certain suspicions about Mr. Zuckerman, but he didn't know what he was going to find. He didn't know what video he would capture, what screenshots, what PowerPoint slides. The evil plot was presented to him at the time, and they took advantage of that, perhaps, because he wanted to have the public see what it was. But when he was doing it, he didn't have a financial motive. So if he got some financial benefit afterwards, that is not a fact that is useful to determining what his motive was at the time. So the government has not shown that the interception took place on a system that affects interstate commerce, and they have not shown that Mr. Weasel had a purpose at the point of the exploit of commercial advantage or private financial gain, and therefore we ask you to acquit. Thank you.
Thank you, Mr. Opsahl. And I've been told by the prosecution that there's no rebuttal, closing, or summation. So now we move to jury deliberations, which is the part where now you get to tell us what you think. How do you want to do it? You want to go with
Yeah, I
count two
mean, this
first?
is really a panel now. We transform from court, court's over. Do you want to take a straw poll? Some years we do, some years we
Yeah,
don't.
let's do a straw poll.
All right, so why don't you put the counts up? Do you want to have a question before the straw poll? Or? Okay.
What's the legal definition of commercial advantage? Does that necessarily include monetary component?
Somebody want to take that?
I mean, the question was, is there a legal definition of the phrase commercial advantage? And does it take, what was the last part? Monetary component. I mean, so answer one is there's no definition in the statute. So we have to look to see if cases have read it pretty broadly to be anything of value.
Yeah, anything of value. So like somebody gave you a car, they didn't give you any money, that would be something of value, and that would probably be private financial gain, actually, if someone gave you a car. For commercial advantage, like if you were working for a corporation and you did have shares in that corporation and they were being a much more successful competitor as a result and your shares gained in value, that might be either a commercial advantage or a private gain. So we tried to make this a hard question by having it be a nonprofit, by having it be an open source thing.
I mean, Hacker Court, we always talk about what's teachable moments. One thing that's clear is the jury, if you were sent back to the jury room, would probably ask that very question. You would come back, write a note to the judge. The judge would excuse you. The lawyers would fight like hell over it. And the judge may just come back and say, it means what it says, and I'm not going to tell you more. Or the judge might construct some very carefully crafted language that we've all kind of convinced the judge to agree on. So, okay, so knowing that, do you guys want to vote on count 2? So this is where the big fight, this was about the screen grab, which I think got a little complicated. But so if you vote in favor of the defendant, if you vote to acquit, which probably means you thought that this did not affect an interstate or foreign commerce system, please raise your hand now. You're voting to acquit on count 2. Bastards. Okay, now of course I have to ask the opposite because some of you just may not know. If you vote with me, and my 2 young children, to convict on count 2, raise your hand. All right, so unlike students in my law school, almost all of you voted. I'm very happy to see that. So, of course, I didn't get the unanimous verdict, but I might have gotten 12. That might be a record for Blackhat.
Is that how it works?
You have to get at least 12?
Any 12.
Any 12. Mm-hmm. All right, count 3. Count 3, again, boils down to this last element, commercial advantage or, and it's only an or, private financial gain. So again, if you vote for the defendant to acquit, meaning you saw no motive of commercial advantage or private financial gain, neither one, please raise your hand. Ooh, even more, I think. Okay, and again, Max and Eleanor are their names. They're 5 years old. Very cute. If you vote with the prosecution for a conviction,
Objection, Your Honor.
please raise your hand. Yeah, so fewer. Okay, so that's interesting.
Yeah.
I mean, under the unanimous rule, there's no conviction, but this shows that, the government argument wasn't completely ridiculous this year.
Hard question.
Okay, so now we'd love to just make this a panel. I mean, questions about any of this? Yeah.
Well, actually, before the question, I'll just start and say that taking off my defense hat and putting on my privacy advocate hat, I think that ROP reasoning that I was going through is a load of something I'm not going to call any result by a federal judge, but
Shit.
the idea that someone could be monitoring your communications activity on your computer, but because it's doing it between components of the computer rather than between the computer and the internet, I think would absolutely eviscerate the wiretap statute's protections. And actually, this is something where EFF and the DOJ actually agree, because it's the DOJ that brought these cases for key logging, and which we think is very analogous to this screen capturing. But anyway, sure. Well, also for anyone who was wondering what Vaporospora was, that was a joke about Diaspora, which is an open source social network project that some NYU students were seeking funding for at the beginning of the summer. They were looking for 10 grand so they could work on it over the summer. We took a little jibe at them calling it vaporware, but then again, they're coding it right now, so hopefully there will be something soon. But
they raised an incredible amount of money. There was
Yeah.
a lot of interest in the project, and it got.
They were only looking for 10 grand, but because Facebook was having a big privacy problem around the same time, the New York Times did a story on them. They raised almost 200 grand. So if you were wondering.
All right, do I have
Why
questions?
don't you tell people, yeah. It's a good question. So the question is, what's the difference between keylogger, screen capture, and someone just grabbing a camera and taking an analog picture of, or digital picture of whatever's coming off the screen? So they should be a defense attorney. Through a window. Yeah, but which way does that? Oh, that would be the defense's argument in this case. Yeah, that would be the defense's argument. I mean, it's as we work through this case, and it's strange because these are all made up facts, but they always become interesting. We have legal fights about this when we're putting the case together. It's weird, right? Congress had this law that's supposed to be about online wiretapping, but it really fits very poorly with TCP/IP and with the way this all works, right?
Right.
With the phones, it all made sense. Phone, wire. Right?
Well,
Things are a lot more
and it does,
complicated.
and because it's more obvious that a phone affects interstate commerce, and there's also legislative history to show that that's clearly what they were meaning with it. And it would be a harder argument to say that the camera is capturing communication that affects interstate
Why not?
commerce.
Why would it be any harder? I don't think it'd be any harder. I think it's the same
the
argument.
receiver of the
Yeah.
phone. It's the,
Yeah. So I prosecuted a case that involved a guy, same statute, but it's traditional voice, a guy with his speakerphone on who was scribbling down notes, who was tape recording using a regular over-the-air tape recorder, and we said, oh, look, there's 3 different interceptions happening. But we had a lot of fights over this, right? But the fact that it was jumping over this air gap didn't make it less of an interception as far as I was concerned. It was hard, though. We really had to struggle with that.
Although that's a wired communication definition.
I know, you're right.
And it
doesn't have the
bring in
interstate system. Good point. Good point. Yeah, it's a good point. It doesn't have that definition. Yeah, I mean, one thing that's clear that I should have made clear in that answer is this is the exact same statute. So the wiretap, thou shalt not hook alligator clips to a phone line was amended in 1986 to include network interception, although there are different definitions. And the one we're fighting over right now with interstate is only about the electronic side of things, not the wire side of things. You want to just call on people? Why don't you be there?
yeah, go ahead.
Yeah, I have a question in number 2. Why wasn't the argument that there was some sort of knowledge or consent to be recorded already present because of my TwitFace's security policies?
Yeah, these are all good questions.
Well,
The question is about consent in terms of service. You want to go ahead?
Oh, well, for what it's worth, we're considering, it was getting somewhat complicated as it was, so we didn't include this, but one of the things we were considering to make it a little bit more interesting was to have an argument about some statements that the CEO would make about how his life is an open book and he's all about openness and transparency, and say, okay, well then you had opened this up. But we ended up not doing the raw question of whether there was an interception, and had him confess to that and such. The getting onto the computer, getting inside their firewall by accessing Brutish's computer with the Snuffleupagus password, you couldn't make a particularly good argument that was a access with authorization.
And I mean, the other thing I would say, there's a lot of interesting legal issues here, but this really, if we introduce that fact, if we said that the CEO signed a policy that said, I have no privacy on this laptop, the government, I think, would still try valiantly to argue, that's consent in terms of this one party, Maria Battaglia and the security staff. This guy, right, happens to be using the very same tools, but he's not the guy I consented to. And this isn't the circumstances I consented to. Actually, as I say it out loud, it's not a bad argument at all.
No, it's a.
Yeah,
It's
I think it might be a winner. It's
I mean,
probably a winner, yeah.
I mean, the policy would say, you recognize and consent to my TwitFace's monitoring of my TwitFace computers. So I don't think that would be a very good argument to say that by agreeing to that, you've allowed this non-my TwitFace person to come in and do the same thing. That could come up if the government did it, because and the analysis turns into a constitutional question, a Fourth Amendment question of whether you had a reasonable expectation of privacy that you gave away when you signed that agreement. Because the government's position is essentially that expectation of privacy is an on-off switch, and if you have given up an expectation of privacy as to one party, then you don't have an expectation of privacy in that information at all.
And that was the case. The Supreme Court just decided not to address that issue, and this was I'm sure some of you followed the SWAT team member who was given the text pager and then used it to trade messages with his wife and with the woman he's having an affair with. And this was also the oral argument where Chief Justice Roberts said, now how does a pager work? What happens if someone's using their phone when you need to send them a page? And Justice Kennedy helpfully chimed in and said, I think you get a busy signal at that point. So it made you wonder about whether the Supreme Court was ready to decide this, but Kevin's right. Under the Fourth Amendment, it's absolutely give an inch, take a mile. You can't consent to lots and lots of, if you give your trash to your trash man, then you're also giving it to the rest of the world. I mean, that's just the way the Fourth Amendment works. Very, very different analysis than the one we did here.
I think we got about 10 minutes with other questions.
Weasel actually had a question.
Oh, sorry, okay.
Yeah, I had one real quick question. During the prosecution's closing arguments, the statement was made that the jury would have to go away to interpret the law. I was under the impression that it was the judge's job to interpret the law and the jury was supposed to interpret the facts.
Oh yeah, no, that's complete. You have it backwards. No, you're right. You're exactly right. One thing we manufactured in this case is this interstate question was really a very legal question, and legal questions usually don't go all the way to the jury. Right. And so we were faking that because we wanted you guys to think about interstate. That the jury probably would never be left with that ultimate question. They might be left with some of the surrounding questions. Where did the interception take place? Where on this, in respect to the network interface was it? But they definitely wouldn't get the ultimate legal question. So that was a very perceptive catch.
Go ahead.
Does the communication in question actually have to cross state lines, or does it just have to go over a system that crosses?
It's only the system.
The latter.
Yep. And the cases are actually specific on that. It says it does not have to have left the state.
Yeah.
And just because the law professor in me wants to make this all about everything that you're reading about in the newspapers, the reason we have interstate commerce requirements like that is because courts have said that's the only thing Congress can do. That's what distinguishes the feds from state legislatures. So Congress always has to make sure that there's an interstate component, but they can stretch it really far. And this has been ripped from the headlines because in all of the healthcare lawsuits, where the state attorney generals are arguing that Obama's healthcare plan is unconstitutional, this is their argument. You're talking about something that's all within one state, and you're forcing people to do something, and this isn't the role of Congress. They're going to lose really badly, but this is very similar to the argument they're making. So.
Okay. Yep.
I was wondering, why does it matter that, why would you not argue that because the screenshot was later sent across the internet, that it was not, how is that distinct from?
I think the argument there would be that there was no interception. So to intercept, and I was sort of trying to get at this in my motion. Under federal law, if you're a party to the communication, you can't intercept it because consent of a party makes it okay. And so the communication of the exploit sending the screen grab to him, he was a party to that communication, and that communication is a separate communication from the communications that Zuckerson was having with his friend in Alaska via IM.
So, is there a reason that
if you're a party to the phone call in the first place,
You can record it.
you can record it under
Under
federal
federal law.
but not under most.
Yeah, but his point is, if he was a party for the, this is why I asked you this question. Does your argument turn on him being a party? And you correctly answered
Yeah.
no. Because if you'd said yes, I would have done what he did, and says, well, then why does
Yeah.
the oral have to do with any of this?
I mean, I should have been clearer, because the point that I was sort of getting at there was that, yes, there was an electronic communication here that went to him, which was, the video screen capture being sent to him, but that's okay because he was a party. But the other communication that they're claiming was intercepted, which was the communications at the party that were captured, well, it was just silent video, and the statute doesn't cover that. And so that's what I was trying to get at.
Here.
I guess I had a question about the definition of the system. I think you brought one case law that said like define the system very narrowly, and then I don't know how this proceeding. Well, you said it wouldn't go to the jury; it would have been decided by the judge. But how could we expand the system to be like all-encompassing when it's already narrowly defined?
So you're absolutely right. That would be a judge question. And one of the things that actually Paul was pointing out was that was a particular court, the Central District of California, and that means it's not binding on other courts. Even judges in the Central District they might tend not to, but they could disagree with it. So for California, the next level up is the Ninth Circuit, which is also for Nevada and Arizona and Hawaii and Alaska and several other western states. And so Ninth Circuit decisions are binding on district courts. Ninth Circuit is binding on all the district courts within its jurisdiction. And there are other circuits depending on where you are. And then the Supreme Court is binding on all of them.
Would it be a fool's errand to argue, for example, if one captured a voice call, that there's no auditory component because it doesn't become auditory until the data is processed through a codec that understands the data should be processed into sound?
We've heard this argument with encryption before. So the question was, is this too clever to say VoIP calls are not voice calls because they have to be post-processed in some way before they become voice? That seems like I think most judges, even not knowing a lot about computers, are going to be really suspicious about an argument like that, right?
I think the judges would do a force for those.
Yeah, with SS7 and with current digital telephony, I mean, that you would if I were the one arguing against it, I'd say, Your Honor, they're just trying to use some accident of technology to rewrite the entire statute, right? But with crypto, it's harder. I've heard people make the argument that, and there's one definition we didn't fight over here. In order to be a criminal under the statute, you have to obtain the substance, meaning, let me finish, or purport of a communication. And I've heard some people argue that with crypto, I don't know, maybe I don't have the substance, meaning, or purport yet, right? I mean, maybe.
Someone was arguing.
Oh, I thought it was Kevin.
Yeah,
Someone with a feed that sounds just like Kevin. That's a pretty good. So anyway, so that's the, but I think most of us up here probably think that's kind of a crazy argument.
I don't think it's crazy.
Oh, you don't?
It is a colorable argument, as lawyers like to say, and if I were a defense attorney, I would certainly make it. I don't think there's any clear law on it. I think I don't think it's the best argument ever, but it is. I'll just say, in another context, when I was thinking about this and was thinking about VoIP as a wire communication, I did stop myself and go, wait a second. There really isn't any case law on this, and one could, so I've had the same thought, which makes it colorable.
Yeah, it has
2 gigs.
So it's a sign of how complicated this statute, which is called the Wiretap Act or Title III, is, that in your answer, I think I spotted 7 legal issues and probably 14 cases. So understand, we presented one of those 7 in this trial, right? There's this whole thing called councilman, and Rick and I were the lawyers who litigated. I mean, we could talk about this all day long. It is an old statute that is really showing its age with the internet. And with every advance in communication technology, it just gets worse. And so lots of people may walk, and the government, let's not forget, this also concerns the government, like I said in my argument, the government may start to get really clever about how it gets around the statute. Well, maybe, possibly.
I'll just add a point to not self-promote, but promote the greater good. EFF is involved in an effort in Congress to, with many partners from both the civil liberties community and companies such as Google. We've been working with Richard to update this area of the law for the 21st century because it is so woefully outdated. And actually, I don't think that anything we're proposing would actually clarify the law on the points raised here, but which only just is a signal of how much work there is to be done here. But just so it's called digital due process. If you want to go check out what we're doing. In the back.
Yeah, just curious about Gaspar. I'd like your opinion.
Raffle starting at 6.
Exactly.
By, get a raffle.
I mean, understand one thing, which is we had him dead to rights on a misdemeanor, so he was probably going to go to jail for something. Some misdemeanor people don't go to jail at all, but probably maybe for a few months. So this fight really was, it was a realistic fight. This happens with the Justice Department all the time. The FBI doesn't want to invest a lot of resources just for a misdemeanor. And so, this was all about the felony. As Kevin said when he led off, the whole keylogger, screen capture, ROP thing, that just can't be right. And so I hope we'd be able to convince a judge, not a jury, but a judge, to disagree with that other court and give us the verdict there. And the other one,
Apple iPad at 6:45.
nice, 649. What was the other?
Someone's okay.
Yeah.
The commercial advantage.
Oh, and the commercial and private advantage. We haven't talked about that at all. It's pretty broadly defined. I think the government would have won that one too.
I mean, it's defined as anything of value. I mean, I don't think I agree that the government would have necessarily won that, but nevertheless, the case law is defining it fairly broadly, and so in trying to make this an interesting case, we put a lot of effort into creating the hypothetical where our esteemed defendant is not getting any salary, not getting any money, he doesn't have a financial interest, and so on and so forth, which, there are people out there who do that, but it would have to be sort of a rare circumstance. One fact that might have complicated it further, which we discussed but ultimately didn't put in, was if the open source project was receiving donations as a result of this. That would be perhaps weigh a little bit more towards commercial advantage. So we tried to make it an interesting question, but I think in a typical scenario which was not so sort of carefully crafted to be interesting, it would be more likely that a commercial advantage would be found.
Cool, you want to call?
I think we're done.
Okay with that, 6 o'clock. Want to thank everybody for coming.
Appreciate it.
Thank you.
Very much.